Module 2, General Techniques Used in Court. Video 1, Communication Techniques. Topic 1, Communicating directly with the person appearing before court.
In communicating directly with people when they come into court, I generally greet them and ask them to sit down next to their lawyer. And if I don't greet them, I at least acknowledge their presence. When they do sit down, I frequently would tell them that what I would be doing is asking them at the completion of the plea if there's anything that they wish to say. And certainly at the end of the plea, that is, after their lawyer has spoken to me and possibly the prosecutor addressed me, then I'd ask the person if they wish to say anything. I always tell them that they're not obliged to say anything, they don't have to say anything to me if they don't wish to, but I do encourage them to speak directly to me. And certainly on deferred sentences, I would say to them, when you come back next time, then I'd be interested and be keen to hear what you have to say about what's occurred over the deferred sentencing period, rather than just listen to what your lawyer has to say.
The first thing I always do is get eye contact with people because they're scared and concerned about what's about to happen. So I get eye contact with them, which is a simple thing, but I think a very powerful thing. And I make sure the lawyer lets me know who their client is and who's with them. So for example, there might be family who are with them, or other support workers or other people with them. So introducing all those people. And then I'll always make sure, just a simple thing, that they can see me. So often the lawyers just sit in front of their client, so you can't even see their client. And so I just make sure everyone's positioned where they can be seen. I'll usually talk with the lawyers predominantly, but I do at the end of a plea will often use that opportunity to engage directly with the person in court, because it's about them and it gives them an opportunity to feel part of the process, which is very important.
Sometimes the lawyers are very reluctant to allow their client a voice in the proceedings, and I think what you have to do really is, over a long period of time, you build a relationship of trust with legal practitioners so that they know that if the client's going to say something prejudicial, that you'll do your best to stop that happening and stop that relaxed process from compromising the integrity of the justice process. So it's just something I think that you build up over a long period of time with the profession.
If the accused is represented, we'll pretty well always engage with the legal representative, but when it comes to sentencing, or if there's a grant of bail, then at that stage I'll certainly direct my remarks to the accused and engage with the accused if the accused wishes to say something.
Topic 2, Explaining court orders and processes.
I certainly endeavour to explain court orders to people, because I remember as a barrister people coming out of court with me and them saying to me, what happened? It seemed very clear to me, but it's plainly the case that many people who go to court because they're anxious and nervous really don't listen. It's not because they don't want to listen, it's not because they're not interested, but they simply don't take in what's being said. So I endeavour to say things in straightforward language, try and remove as much legalism from the language as possible, still of course consistent with the law, but in language that is more straightforward, might even say more user-friendly, so that people then can understand and take in what's being said. It's also important in, not just in criminal matters, but in family violence and personal safety orders, that people have a clear understanding of what the orders are.
I think it's important to get people into a state where they feel as comfortable as possible with the fact that they are in court, but that they do have a voice in the proceedings. And when I do address remarks to them in terms of either advising them of their bail conditions, or why I refused bail, or what the sentence is, I endeavour to instil in them a sense of accountability as well. And I make it fairly plain to them that I have an accountability to the community, they also have an accountability to the community. The therapeutic aspect of it is not all one way. It's about fostering their understanding of what's expected of them.
It's still a court of law.
It's a court of law, and my expectations of their behaviour are quite properly spelt out.
Topic 3. Using a less formal approach in court. The approach taken in proceedings at the NJC can be described as less formal rather than informal. A level of formality is maintained in all court proceedings, and in many respects, court hearings and court processes at the NJC reflect those found in other magistrates' courts. In addition to speaking directly to the person appearing before the court and having them sit at the bar table, Magistrate Fanning takes a less formal and flexible approach by standing matters down when necessary and using adjournments to enable issues to be resolved prior to sentencing.
Of course, one of the things I do is have the person sit down next to their lawyer, certainly in criminal matters, different in family violence and personal safety issues, but in criminal matters I have the person sit down next to their lawyer throughout the proceedings, unless they're in custody, in which case, of course, they remain in the dock. But for the majority of matters, they sit next to their lawyer. So that immediately has a sense of engagement with the court, because they're not sitting behind their lawyer at almost halfway down the courtroom. They're already partially engaged with the court already. And particularly if I take the opportunity to speak with them directly, which, as I say, I do at the outset. Now, the benefits of that is that, one, as we all know, if we're at least partially involved in the outcome of a decision that affects us, then we're far more likely to follow through with that decision. Most people are apprehensive. They are reticent to, they are slow to, it doesn't come comfortably, quite understandably. It certainly helps if their lawyer, and all of the legal aid lawyers and the other lawyers who regularly appear in the court, will tell them that that's the practice at the Neighbourhood Justice Centre, and practice in my court. So they will have already been told that I'm likely to ask them if they wish to say anything to me. So rather than it come as a surprise, because frankly if it comes as a surprise, then they're unlikely to be able to put any words together, particularly on the first occasion. So it gives them opportunity to think about what they might want to say. And when they do say things, they very often say things that are relevant and things that the lawyer hasn't said. Sometimes they say things that are, you might say, are against their interests and are contrary to their interests, but you really take those with a sense of grain of salt, that you don't put a lot of emphasis on them, and you really accept that people who are not familiar with court proceedings, some people are of course, will say things that might horrify a lawyer because they say things that are seen to be contrary to their interests.
Sometimes one has to be circumspect about to what degree they discuss a case in a busy list.
In front of people.
And I'm a great advocate of introducing the therapeutic jurisprudential treatment of all offenders in mainstream court. But one has to be very mindful of discussing personal matters in a crowded courtroom. And there are times when we'd like to engage, but we really do need to be mindful of people's privacy.
Engaging them impacts in a number of ways. Firstly, they believe they have a greater understanding of the outcome and a greater understanding of the process by which that outcome has been arrived at. And further, that they are more likely to comply with, to accept and to respond to the outcome of the court.
Module 2 also includes the following resources: Video 2, Engaging with Treatment and Service Providers, background materials, tip sheet,